Hello, everyone, and welcome to today's webinar presentation, Navigating New Pay Transparency Policies, a Look Across the U.S. Coast to coast, states and even some cities have begun to implement pay transparency policies. While this employment law trend has noble objectives, like improving pay equity and employee trust, it also presents employers with new potential pitfalls. During today's presentation, Libby Henninger and Joy Rosenquist will provide you with an overview of these new policies and how to best navigate them. Before we get further into today's topic, I would like to take a moment to introduce myself and my organization. My name is Zielinski, and I'm the Marketing Director of ComplianceHR. You may recognize my name from the email invitations that you received for today's event. To prevent a few popular questions from trickling into the Q&A box, I would like to let you all know that you will be sent a recording and a copy of the slide deck from today's presentation. So keep an eye on your inbox for an email from ComplianceHR webinars. Now, a bit about ComplianceHR for anyone who may be unfamiliar. ComplianceHR is a joint venture between two incredible and innovative organizations, the AI technology company Neota and the law firm Littler. ComplianceHR delivers expert employment law guidance in a fraction of the time it would take for traditional methods. Our goal is to simplify the complexity of employment law, something that we will learn a lot about during today's presentation. To achieve that goal, ComplianceHR offers a suite of technology solutions around critical HR compliance topics, like employee overtime, independent contractor classification, employee handbooks, onboarding, leave, and more. Today, however, I would like to introduce you to what we call our compliance essentials, PolicySmart and the Reference Center. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and even automated emails to alert you on new legal changes going into effect. The Reference Center is a solution created to help you and your team quickly answer employment law and HR compliance questions. With information on a wide range of compliance topics and deep insights that bridge multiple compliance concerns, the Reference Center aims to help HR and legal professionals do their job more efficiently and effectively. If you're interested in learning more about our solutions, a survey should have popped up on your screen during the last slide. Now, if you're in full screen mode, you may have to exit to see the survey, but if you would like to sign up for a demo of the Navigator Suite, simply answer yes, and I will send your contact information to our team of experts, and they can have a deeper conversation with you about your compliance strategy and how ComplianceHR can help. In addition to a demonstration of our solutions, you may be eligible to receive a free trial of our products so that you can see precisely how much time and money they can save you. If you're not sure at this time, I'll put the survey out once more before we conclude today's presentation. Now, I have the pleasure of announcing today's webinar presenters, Libby and Joy. In addition to their backgrounds in pay equity, wage and hour law, and employment law compliance, Libby and Joy just authored an article in January on the continued spread of pay transparency moving to DC, making them today's experts on this topic. Joy and Libby, I'll pass it over to you.
Wonderful. Thank you so much, Stephanie. And thanks for everyone joining us this afternoon. And I'm already getting ahead of myself. Apologies. So thank you all for joining us this afternoon. I just wanted to give an overview as to what we're going to be discussing here in the next hour or so. As you're all here to hear about, we're going to talk about the emergence of pay transparency laws in the United States. There is a federal bill that is currently pending in Congress. It has not been passed, but there is no nationwide federal legislation on this issue as of yet. So what we're left with is this kind of hodgepodge of state requirements, which we are going to cover. And it really started with, in large part, with Colorado in 2021. And we're going to cover what that law looks like now in its kind of iterations, as well as the multiple states that have have followed Colorado and require employers to disclose salary ranges and salary pay scales in job postings and in other notices. Now, the idea and predicate behind much of this legislation is to help decrease gender pay disparities. However, as you'll see going through the overview of the legislation that has been passed and that's contemplated as pending in different state legislatures, there's a lot of variation with these laws and requirements, which makes it incredibly and increasingly difficult for employers with multi-state operations or operations that lend to remote workers to comply. So today we're going to be providing an overview of those legal requirements, as well as some strategies that you can consider for compliance. Now, just to kind of level set where we've come as frequently as the past 2 years and looking at some recent trends, wanted just to provide you with what we've been seeing. Even in the past year and a half, we have seen such an increase in pay transparency and salary disclosure in job postings, and that's even coming from October of 2022. We've also just seen, as we've talked about and is identified here, an increase in those requirements at that legislative level to disclose salary information in job postings versus just disclosing that information at the time of hire or even at a job interview. This has extended to positions that can be filled remotely at a location. This gives a little bit of an overview as to what it looks like in the United States right now. I mean, as you can see on this map, we have the states in orange are those that require actual pay scale disclosures in job postings. There are several jurisdictions that have pay scale requirements that in job postings that are not currently in effect. And then in green is where we're moving and where we see continued movement, which are states with pay scale legislation that's pending, have not been enacted yet, but that's pending. And we do anticipate that this trend is going to continue, which is why it's something that that we're talking about today, so that you can figure out how you'd want to approach it as you're looking at hiring practices and how you're setting compensation.
Hi, thanks Libby for that introduction. And my name is Joy Rosenquist. I'm coming to you from the Sacramento, California office. Unfortunately, I don't have the capital in my background. I've got the river in the background. If you zoom in real close, you might be able to see it. So I want to talk a little bit about the concept of wage transparency. It really is not just what you are required to disclose in your job postings. It does take many forms. So pay scale disclosure requirements, as you'll see later on in the presentation, can be anything from requiring you to disclose a pay range to requiring you to disclose it only upon an inquiry, or to disclose it after you actually interview a candidate. That's kind of the least restrictive version. And then another form of wage transparency is the pay data and demographic reporting that we have here in California. Really can be quite a burdensome reporting obligation. Many of you do the EEO-1 already. California has its own pay data, and there is a pending bill in Massachusetts that we'll discuss in a second. And then again, we have these salary inquiry bans, another form of wage transparency, which essentially says you cannot set someone's salary based on what they made previously. So although you may not be required to disclose outright the pay in a job posting, you are not permitted to inquire about a prior salary. So let's look at this list that I kind of keep current as much as I can. There's a bunch of states with salary bands for the inquiry. And then there's also cities and counties that have the salary inquiry prohibition. So you really have to stay on top of those localities as well, these cities and counties. And just because there's no pay scale disclosure requirement in a state you might be operating in, you have to make sure you're training your HR team that there could be a salary inquiry ban. So let's move on into our overview of the state of the states. And we have to start with Colorado. So Colorado, as Libby mentioned, was the first state to really get involved in the pay transparency disclosure requirements. So Colorado applies to all employers that only have at least one employee, right? That's a very low threshold. So that essentially applies to almost every employer. So we are already in year 4 with Colorado, and Colorado also recently became the first jurisdiction to actually require application deadlines and postings and notifying incumbents if there's an opportunity for a promotion in the workplace. So they have quite a few detailed requirements. You will see a lot of detail in the slides. I won't necessarily be discussing every detail of each state because you can refer to these later. We want to really highlight the important points here. So one important point for Colorado is that the position in which you must disclose the pay scale applies to any job performed in the state or that can be performed remotely from anywhere. Now that really is potentially kind of everywhere. That puts you in a bit of a bind if you have a fully remote position in terms of how you disclose the pay scale for that or whether you have to. So in Colorado, the compensation range is a reasonable estimate of what the employer, in quote, good faith, believes it will pay for that position. And you also have to disclose the benefits and other forms of compensation. So when we go through the states today, you'll see that there are some that just require the wage range, some that require benefits, and then some also require other compensation. And so we will be calling those out for you today. So Colorado has this application deadline. This is really unique. I haven't seen this in any other state's law, but essentially you have to tell people when they must apply. There is sort of an exception here called the evergreen posting. So a lot of you post job positions that don't necessarily have a deadline. It's a rolling basis. So you may have a posting that says the company is accepting applications on an ongoing basis. So that was sort of a welcome addition to the law for a lot of employers in Colorado. And continuing on with this state, because there's so many rules in Colorado's wage transparency law, the promotional opportunities disclosure requirements, these are a little bit detailed, but essentially Colorado really is way ahead of other states here. But we want to go over this because Colorado, even though you may not be in Colorado or advertising in Colorado, it really is a glimpse of what's to come, kind of a crystal ball, so to speak, of what could be coming in other states. So they've had a few years to implement this law and have already had amendments to it. As other states are watching this wage transparency experiment, I anticipate this is next, the promotional opportunities disclosures. So employers have to give their current employees notice of all job opportunities throughout the entire company. And this really is a current or an anticipated vacancy for which you're considering a candidate. So as you are considering promoting people, make sure you're consulting this law to see what you have to disclose. So here's some of the disclosure requirement exceptions. So you have to disclose for job opportunities. There are exceptions. These are the exceptions for the job opportunities. So one of them is career development, in which you're essentially updating someone's job title, or you're compensating them for work already performed or contributions that have already been made and kind of changing their title and their comp to reflect that. Another one is career progression. These are those leveled positions, accountant 1, 2, 3, 4. junior designer, senior designer, things like that. And then of course those interim positions. So there's changes this year as well. They've gone through a few iterations of changes, but these are brand new. So the career development positions are now fully exempt from posting requirements. And of course, there's the career progression amendments as well. So those are exempt from posting requirements, but they have their own specific details, as you'll see in those bulleted points. So if you are considering whether an exemption applies to the position for career development or career progression, you want to really consult those regulations. So again, last slide here on the Colorado changes in 2024 is that they've enacted amendments to say, let's protect those small businesses, right? So if you are an employer with no physical location and you have less than 15 employees, and those are not physically located outside of Colorado, then you are exempt from a lot of these amendments. So that is supposed to sunset July 1, 2029. We will see how that one goes. But that is also a welcome amendment to the smaller employers in Colorado. So let's see here. Oh, one more. Okay, because there's just not enough. There's not enough going on in Colorado. One more slide here is that there are also changes to the scope, the geographic scope of what attaches. In 2021, when Colorado enacted this law, it was really vague and kind of carried extraterritorially into other states. So a lot of employers in neighboring states said, well, we might be hiring someone in Colorado. Does this apply to us? We're not sure. So now they've limited the geographic scope for the pre-selection notices and post-selection notices to only apply to Colorado employees, not out-of-state employees that may or may not be working for a Colorado company. So that's great news. It means only Colorado employees need to get those post-selection and pre-selection notices. I don't expect you to memorize all of this. The slides are a great reference tool for Colorado, but please do seek those regulations out when you're making a decision. Now that we've heard enough about Colorado, I'm going to turn it over to Libby to talk about Washington.
Thanks, Joy. So yeah, so Washington really became, after Colorado, the next state that enacted a pay transparency rule that required disclosure of salary information in job postings. And this law went into effect beginning of last year, so January 1st of 2023, and it applies to employers of 15 or more who have 15 or more employees with at least one employee that is physically working in Washington. So this could be a remote worker, could be you have a small location in Washington state. That's really the scope of the application, but one remote worker could trigger the applicability of this law. And what really this law requires, as Joy had mentioned, there are laws out there that have those different requirements, salary being one of them, the salary or salary range or pay scale, others being benefits and other compensation. This one's kind of the trifecta. It requires all three to be disclosed. So here in Washington state, the job posting has to include the wage scale or salary range, a general description of those benefits that are provided, as well as other compensation. And so let's kind of walk through then what each of those specifically means. So looking first at the wage scale or salary range, this is really the lowest to the highest pay established by the employer prior to publishing that job posting. And you have to have the pay already established prior to posting the job. which I know sounds logical, but there are some times where that doesn't actually apply, where it is commensurate with experience. You might see sometimes in job postings, or pretty large ranges, or the range might change. I mean, this actually, you have to set the range prior to having the job created. You have to create the range prior to it being posted. And if you update the range, so if you go through and you do your interviews and you decide that, or you review the applicants, or you review the job or the needs of the business, and you decide that the range is going to change, you have to actually update the job posting to include that. You also have to include other compensation. So now what does this mean? Because this can get kind of tricky as to what other compensation is. So the good news is, if the job has any sort of base pay or set salary, an hourly rate or a set salary, the other compensation that's offered can be identified fairly generally. So it can it can say commission eligible or bonus eligible. There can be a general statement, so long as you're identifying with specificity what the range is for the base pay. Now, for positions that don't have that base pay, so they're either 100% commission, or maybe being paid on a piece rate, or some other compensation structure, you do have to provide specificity in terms of how the compensation structure is going to be set. So if it's a commission-based position, you're going to have to identify some sort of specificity as to how the commission is based. And if it's a piece rate position, you're going to have to provide some sort of specificity as to how the piece rate is established. You also need to provide a general description of benefits. And here we've kind of identified what those benefits could be and what the general description could be. You can provide the general description in the policy, and more detailed information can be linked. So you can say, generally we provide health insurance and medical and dental and paid holidays and things like that, and then you can link more. You can link to more specific information. Now, here is the update with regards to Washington State. Currently, the law allows for a private right of action, and it also allows for class actions. There's a proposed amendment that would allow for a notice and cure period for employers before such action, such private action could be taken. We've kind of outlined what the proposed amendment would be. There would have to be a notice that the employee would have to notify the Department of Labor, or would have to provide the employer with some sort of notice, and then there'd be a cure period that would have to be undertaken and exhausted prior to any sort of private action being taken. Now, we see this come up also in New York, which we'll talk about in a second. So this is also something that is on the radar with regards to these pay transparency laws, in terms of enforcement action, that there are some that do allow employers to potentially cure violations of the law prior to having enforcement being taken against them. Which I guess that's one good news about these laws, right? That you do get a little bit of notice potentially. Now, turning to New York, New York has, we'll talk about New York in kind of two parts, because New York has New York State, so there's a statewide law that's in effect, that covers obviously all of New York State. Excuse me. And then there's also one that applies to jobs in New York City. So looking first to New York State. So this is the most recent law. This law took effect September 2023. And this law requires that all employers have to post those salary ranges in job advertisements for positions that in whole or in part are performed in New York, or for positions that report to a New York-based supervisor. So those are the two categories. So either the position performing work in whole or in part in New York, or it's reporting to someone or taking direction out of someone that's based in New York. So what does this specifically then mean? So it means that remote or telecommuting opportunities that report in to a supervisor, an office, a work site, some sort of reporting structure in the state of New York are covered by this law. So if you have a headquarters, an office, a manager that sits in New York, and you have teleworkers around the country, that they're all covered by this law, and that's how coverage is extended, regardless of where they're working. Now, just those occasional appearances in New York, if it's just for conferences or meetings, that's not considered coverage, but it would be if there is an actual nexus or basis in New York. Also, it includes any posting not only directly done by the employer, but it extends to third-party postings. So, postings by third-party websites doesn't have to just be postings that are put up by the employer, either internally on their website, internally facing to the company, or to the public. So what specifically needs to be disclosed? So the disclosure needs to be the pay range, and the pay range cannot be open-ended. It has to be specific, and it has to be done in good faith. And at the time that you are posting for the position, you have to be able, as an employer, to establish that whatever you're posting, the amount that you're posting, the range that you're posting in the job posting is what you would legitimately and in good faith pay for that position and offer for that position. And if it's completely commission-based, you have to clearly state that when you're advertising the opportunity in the job description. You don't have to specifically indicate, though, anything like we had said about Washington State. You don't have to get into that level of specificity, but you do have to indicate that it is 100% commission-based. You also have to provide updates. So you can post a new advertisement with a new range of pay if you feel like you need to increase your budget or increase the range to attract additional candidates. And you also have to be able to justify if there's a significant range. So if you're going to put 100,000 to 200,000 or something as a range, you're going to have to be able to justify that significant that significant breadth of a range and explain why it's so broad. Now, additional compensation doesn't have to be included in the base rate. So things like tips or things like that. But what you do need to include, though, is you have to, you can't lump together different opportunities. So if you have different ranges for different locations, if there are jurisdictional ranges, so a position in Rochester pays a certain amount, but a position in Westchester County would pay a higher amount, you can't have the range include the two locations. You actually have to break it down and identify it with the identification of those possible locations and identify those as multiple opportunities. Similarly, if there are different levels that could potentially pay different amounts, you would have to identify the same and identify the corresponding range. So those are, you do have to get granular, a little bit specific, instead of having kind of the minimum range to the highest range for different opportunities. You really do have to, include a breakdown of those different ranges. Now, a little bit of a caveat here. Where the company leadership and the offices are all located outside of New York, so where there is no connection to New York at all, but the position and the posting for remote, and the position could be remote. So it's a remote, you're hiring, it could be a remote position. You do not have to include the pay range, even if it could be performed in New York. However, if there's a possibility that any of the work could be performed, if by direct supervisors that are located in the state, the position's hybrid, or they're regularly required to report to an office in the state, then the coverage applies pursuant to this law. So it's a little bit more nuanced and a little bit different than some of those other laws that we've seen. And it's a little bit different than the New York City law as well. Speaking of, so let's turn to the New York City law. So the New York City law was actually passed first. So it was passed before the New York State law, which, it's always fun to have a New York State law that state law when you already have a law that covers the city. So the New York City law was passed and was effective November 1st, 2022, and it was not preempted by the state law. So you actually have to comply with both, which again can cause some level of consternation, but it really is targeted towards those ads and towards the, towards your postings. And it's a little bit broader because it covers all ads that can be performed, all ads for work that can be performed in New York City. And you have to include that good faith salary range or ranges for any sort of hourly rates. You don't have to include additional compensation. So it's just really the salary or the hourly rates. And if there's a range in hourly rates or multiple hourly rates, you would have to distinguish that. Employment agencies are covered, but it's not covered if it's a temporary help firm that assigns their own employees to perform temporary work. And it covers ads for jobs only if there can be performed in whole or in part in New York City. So just in the city. So in terms of enforcement, it's a little similar to what we talked about with the amendment in Washington. Although there's no private right of action, but there is a cure period. So this is somewhat as to a model as to what Washington state is looking at, but first have to go through this cure period. And if the violation is not cured, then it goes through an administrative process, and there are penalties that can be assessed if there are continued violations. All right.
Okay.
Well, now we're going to move over to the other coast to discuss what is going on in California.
Right, quite literally. Okay, so you guys are probably all rolling your eyes now, like, here we go, California. I know we are normally a pain to deal with state. I will admit that freely. This law in California is actually not super detailed. It's not super hard to comply with. There's no regulations. It's a very minimal worded statute. There's been no amendments. We have some labor commissioner guidance, but that's it. So let me take you through the pay transparency portion. This came into effect through Senate Bill 1162, January of 2023. So it's only been in effect for a year. And it essentially says you have to provide a pay scale in your job postings. And if employees ask, you have to provide them the pay scale for the position they hold. There is a whole separate part to this law that is also the pay data reporting. I have a whole separate webinar in pay data reporting. And it is due May 8th, by the way, your pay data reports if you have to file those. So I'll mention those at the very end, but let's go into pay scale. What is the pay scale in California? It's a very broad definition. The salary or hourly wage range that the employer, quote, reasonably expects, quote, to pay for the position. So this is different than some states that say we want the minimum and the maximum of what this position is for. So if you're providing the absolute bottom and the absolute ceiling, that may be different than a range that you reasonably expect to pay for this particular position that you're hiring. So there is some strategy there in terms of how you post that range. Essentially, it's going to break down to what are you actually prepared to pay. If you are hiring a more junior level accountant instead of a senior level, maybe your range is on that minimum to mid. If you're targeting a more senior person, maybe it's mid to max. You're not required in California to do the minimum to the maximum. So it's only salary, it's not other comp, it's not other benefits. So unlike some of these detailed requirements in Washington and Colorado, California doesn't have that. Kind of shocking, but we're happy about it. So this law applies to employers with 15 or more employees. The statute gave no guidance on how to count this, but this has come up. Essentially, the labor commissioner wrote an FAQ on this, saying the 15 employee threshold applies when you have reached 15 employees at any point during a pay period, at least one of which is located in California. So that's pretty consistent with how the state has determined threshold coverages for other laws. So the pay scale has to be disclosed in a job opening. A job opening is not defined, unlike a lot of other states went to great lengths to explain what a job opening is. California did not. So we don't think it applies to just a help wanted sign. However, this does apply to third parties posting for you. So if you're using social media as a third party to post your position, that social media company and you are both responsible for putting the pay scale in that job opening. We also see some more vague postings like, as you see in this third bullet, manufacturing job available, apply now. Well, that is probably also just an piece of information, but not a job posting, right? But when you look at other states, that might be included. So you just have to pay attention when you're a multi-state employer, and I know a lot of the attendees in this webinar are, it could very well come down to whether you have to comply. Depends on whether it's actually a job opening or not, and what is defined as a job opening. So separate from the pay scale disclosures and the job postings, the law also added a clause that said you must provide the pay scale to all job seekers without, of course, defining a job seeker. So the prior rule here was that you only had to provide the pay if the candidate had completed an initial interview. Now any job seeker is entitled to the information, but they do have to request it. So in addition, an applicant is also entitled to that information. So they defined applicant really broadly. So this is anyone seeking employment with the employer who's not already employed. Presumably this could be someone surfing the web who comes upon your website and decides maybe they want to apply to something and they inquire on the salary. They would be entitled to it under the California law. So this is a unique aspect of California's wage transparency law that you're seeing in a few other states, but not too many. This is pretty unique, and that the existing employees, even if they're not applying for a position, they're entitled to obtain the pay scale that attaches to the position they're currently holding. So if they say, hey, I'm not really sure what the pay scale is for my accountant position, there's someone that's making a lot more and someone making a lot less, what's the pay scale? You need to provide the pay scale that applies to the position they hold. They're not entitled to know other people's pay scales, only the position they hold. Naturally, once they obtain that information, they start talking, right? This leads to questions about pay differences. So you want to make sure not to step into a National Labor Relations Act violation by asking people to not talk about their compensation. And of course, that also violates the California Equal Pay Act as well. Also, something that's come up quite a bit in employers starting to comply with this law is they may have different pay scales that apply to similar positions, but the position's worded differently. The job is pretty similar. So you really need to pay attention to that so you don't walk into a pay equity claim. Document your reasons for the differences. There is a penalty for violation, but for you golfers out there, you get a mulligan. You get a freebie violation so long as you cure it. I'm not sure what that looks like. If you've already filled the position by the time the complaint comes in, do you have to repost it if the position's already filled? How do you cure? There's no guidance on this, no regulations on the horizon. So lastly, before I move on from California, it's unique in that it also has a pay data requirement where you are now reporting to the Civil Rights Department the pay data for all of your employees in California broken down by race, gender, ethnicity. And you're also reporting on labor contractors now in California if you employ 100 or more, or you use 100 or more labor contractors. Okay, I could go on forever with California, but let's move on to probably a little more fun state to visit in my mind, Hawaii. Haven't been there in a while, but I'm going to try to make that change soon. So Hawaii has a new pay transparency law. It's actually fairly limited as well. Just took effect, so it's only been in effect for a couple of months now. And it only applies to employers that have 50 or more employees. It doesn't apply to public employees either. And that's sort of like interesting side note. Most public employers in any state already have public compensation data, right? It's a civil service position. It's usually publicly available. Maybe Hawaii is different, but they specifically carved that out. So that requires all job listings to disclose the hourly rate or the salary range, reasonably reflecting the position. A lot of you have asked, I've noticed already kind of in the chat, what if there's no range? Well, at least with respect to California, for example, if a range doesn't exist, you don't have to necessarily create one for the position. If you know you're paying $50,000 a year and it's not negotiable, that's what you put in the posting. You know you're only paying $20 an hour and there's no range and it's not negotiable, you just put $20 an hour in the position. So that may not apply to every state, but that is working so far here in California. So moving on from Hawaii, Illinois Pay Transparency Act has been approved into law, but you still have some ramp up time here. So it takes effect next January, so you've got some time to prepare. This law requires employers with just 15 or more employees to include a pay scale and the benefits in the job posting. Compared to some other states that only have the the pay scale required. Some of them also have benefits. Some of them also have other comp. Illinois is applying to that other category, right? That you have pay scale and the benefits. So this is interesting as well because this bill also has a 14-day cure period. And while California doesn't have a cure period, it has a cure opportunity. So it's sort of open-ended. Illinois is a little stricter and says you have a 14-day cure period after receiving notice of the violation. So once you've used up your freebie, then they can start penalizing you up to $10,000. Okay, so now we're going to move on to Washington, D.C., where Libby actually sits today. She can go over this one.
You know, so next on the horizon, and this one is actually coming up fairly soon, is Washington, D.C., which is where I'm sitting. If you kind of lean out, you can see the Washington Monument from my office. And this one goes into effect June 30th of 2024. It was signed by the mayor earlier this year. And this covers at least one employee in the District of Columbia. It doesn't speak specifically to remote employees, but the way it's worded looks like it would cover if you have a remote employee working in the District of Columbia. And the way DC's laws, labor and employment laws, typically work, it covers employees are covered if you work 50% or more in the district, or you work a substantial amount of time in the district and you don't work 50% or more of the time in any other jurisdiction. So we assume that the coverage will likely be the same for this law, unless if the rules and regulations, if they are ever promulgated, would say otherwise. And this law is going to require, similar to what we've talked about, it's going to require minimum, maximum of salary and hourly pay in all job listings and position descriptions. And then it also requires employers to disclose to applicants the existence of healthcare benefits that an employee may receive before the first interview. So you don't have to put it on the job posting, but you do have to provide it to an applicant prior to that first interview, and it's just healthcare benefits. There's no private right of action. It's all enforced by the Attorney General. Okay, so we finally made it through the laws that are actually in effect. We want to do a really quick roundup of just the pending legislation, just so you know what's potentially on the horizon. These have not been passed. We don't really have a crystal ball as to what is going to be passed, although think that likely Massachusetts out of these is perhaps the closest, although again, don't know specifically where the legislation will land, but just want to kind of run through this so that you know what you might be looking at in the next year or so. So kind of first up to bat is Indiana. Indiana has a law, again, that would require the disclosure of wage ranges, as well as that description of benefits in all job postings. This one would have, similar to California's, kind of a mulligan, I guess. I like that terminology. You would get a warning first, and then there's fines. The next one is my neighbor, Maryland, and Maryland's also pending. The likelihood of this passing, our understanding is perhaps we know that there is some, there has been a lot of pushes for this to go forward, so we'll see what the legislature does with this. It would require employers to disclose the wage range and then the description of benefits and the other compensation that would be offered. And penalties would range from a warning letter to fines, so no private right of action here either. Joy, what do you think about Massachusetts?
turning next to Massachusetts, this is an important bill to watch because not only would it add a pay scale disclosure requirement, it also adds pay data reporting similar to California's pay data reporting. So that is really significant. It really would only be the second state to require actual pay data reporting, similar to California's onerous detailed reporting. Illinois does have an equal pay certification, but it's kind of a different process. So this Massachusetts bill would apply to employers with 25 or more workers and would ask for the wage range that the employer reasonably and in good faith expects to pay at the time. Doesn't appear to require benefits or other comp. And picking up on this trend, it's also allowing for a warning for the first offense before penalties are assessed. There's also a pending bill in Minnesota, which has a bit of a higher threshold for 30 or more employees. So the Minnesota bill would require employers to disclose the salary ranges and a description of all benefits and other comp. So it's got all three of those categories. And then in terms of the salary range, this is a minimum maximum state, right? So we've got some states that say reasonable range. We've got some states that say minimum maximum, the floor, the ceiling. So that is what Minnesota laws, well, it's pending, but if it's implemented, that's what the law would be. It's sort of interesting because the statute also maybe has an internal conflict. It says that an employer must post a starting salary range. So is that different than the minimum and maximum? Is that in addition to the minimum and maximum where you would start for this position? It's a little vague, but the joys with pending bills is they are amended all the time. So we will see. Missouri also has a pending bill which would require employers to provide wage ranges only in response to inquiries. So this really is not like a quote pure form of pay transparency because it's only upon request. So you'll notice that the states that Libby and I spend a lot of time talking about today are affirmative disclosure requirements that you must affirmatively disclose the pay scale when you have a job opening. A lot of other states that we didn't talk about that also have a form of pay transparency are the upon request states or only after interview. But we still thought it important to kind of call out Missouri as a pending bill there. Now, New Jersey has two bills pending. This happens quite a bit in my home state of California. We always get kind of competing bills. Looks like New Jersey's got the same thing going. So they have two different bills here. They're not super different. The difference really with the second bill is that it has a geographic scope limitation. So the first bill says you have to disclose the pay scale and the known promotional opportunities to employees, and there's violations attached to it. And it's fairly the same with SB 1107, except that it says this only applies to employers who have physical locations that are in the state of New Jersey. So we will see what happens with those. I'll turn it back over to Libby for Vermont.
Similarly, Vermont has a bill pending that would require disclosure of compensation of range in job openings, and it would be potential applicants and current employees and the general public. And West Virginia, similarly would require employers to provide the wages, benefits, and other compensation. And also, it would allow employers to rely on or confirm a wage history provided by the applicant after the initial offer of compensation. So that one's a little bit of a change as to what we've seen before. And finally, Wisconsin would require, it's pending, would require employers to include the range of the hourly wages or salary, and then there's other benefits or compensation in job listings. And again, no private right of action, but there's penalties that are non-compliant.
Okay, so I would love to fix all of your problems for you, but Libby and I have 5 minutes left to go over some practical guidance. So let's go over these really quickly. You obviously heard about a lot of bills. Littler has a policy arm called Workplace Policy Institute. I'm the California liaison for that. I track legislation. We track legislation in every state. If you want to know what's going on a specific bill, reach out to us. Let's go over a little bit of guidance though, based on kind of what you've heard. So job postings, you have to be pretty strategic with which state you're advertising in. We recommend though that if you have a little bit of discretion in terms of a reasonable range, you can post a minimum and then keep bumping it up if you don't get the right candidate. But if you're in a minimum maximum state, that might not be the best strategy. So it sort of depends on which states you're posting in. And we also want to point out that you can discuss salary expectations, right? This isn't like a subject you can't discuss anymore with applicants. You can ask what their expectations are. You just don't want to discuss their prior wage history. What did you make at your last job? Really avoid that conversation. And then in terms of some strategies for posting your pay range and pay scale, again, this kind of depends on whether you're a minimum maximum state or a reasonable range state and whether you're targeting a certain experience level. If you are a multi-state employer and your HR team can't keep track of all this, you can post one kind of exemplar blurb that will work for all states. That right now is pretty much Washington. If you create a Washington compliant blurb that pretty much complies with all states, maybe that's your solution. So again, we recommend as well that you layer your positions, accountant 1 through accountant 4, HR generalist, senior HR generalist. When you do that, you're able to target comp more effectively. And added benefit in California, when that existing employee asks for the salary range that applies to the position they hold an accountant 1 position. They get the range for that position. They don't get all the leveled positions. That's another benefit of leveling those positions. And let's see, I'll turn it over to Libby to close out with a few more practical items.
Absolutely. So the other things to consider are what to do in this new virtual world that we're living in. So obviously, as we've talked about this, a lot of times remote work or having a remote workforce or allowing people to work, to telecommute, might trigger all sorts of obligations, but obligations with regards to pay transparency. Pay transparency laws will likely apply in the location where the job is performed. So it is incumbent upon you to ask applicants where they're intending to work or to have an idea as to where you're going to allow applicants to work. And it is fine to have restrictions on that as well, that you would only advertise or only allow workers from certain states and have policies potentially in place that require employees to notify you if they're going to move to another place, even if they already have a telecommuting or remote work agreement in place. That would limit them from working in certain jurisdictions. Now, as we've seen, the expansion of some of these requirements and these laws might make that difficult to fully enforce, or you might have other requirements or policies that might make that difficult to implement, but that is something that you can do. You also want to take a look at your compensation policies in general about disclosing and requesting salary information, review the compensation and compensation related policies and guidelines for compliance with fair pay requirements. And finally, because of the focus on pay ranges, you want to evaluate how initial compensation is set. consider conducting pay equity reviews or analysis. Ensure that there's training for recruiters, for managers, not just on pay transparency or disclosure requirements, but also generally on compensation practices and how compensation is initially set, how it's set for promotions, and how it's set for all sorts of different events, to ensure that if you have to disclose this information in job postings, that you have a process that is established. So these are just some of those practical implications. If you have any additional questions or concerns, you can put them in the chat and we'll review those afterwards and we'll try to get back to you on those. But we really do appreciate your time and attention today. Thank you so much.
Thank you.
Libby and Joy, thank you very much for providing us with this overview of all of the new pay transparency policies and how they're truly stretching from coast to coast. I would just like to let all of the attendees know that there is a poll running. If you're interested in signing up for a demonstration of ComplianceHR, simply click yes on the poll, or you can always visit our website. Our solutions do have the ability to pull things like state-specific handbook templates, which will include those policies if they're required in those jurisdictions. So these resources truly are, helping your overarching compliance strategy. All right. Well, thank you all so much for taking the time out of your busy schedules to attend today's webinar event. We hope that you enjoyed the content and have a great rest of your afternoon.